Hi, how are you? I'm Bentley, chair of the Department of Psychiatry. First of all, I want to thank Renee and Rich and Rob for allowing me to provide everybody with just a 5-minute update related to COVID vaccine update. Afterward, we'll begin our long-awaited Steinberg lecture. Let me share the screen. And as you know, September 27th was the deadline to comply to the New York State mandate for COVID-19 vaccines. And that really led to a very complex dialogue and a lot of work by everyone involved in our department. And now that the deadline has passed, I wanted to update everyone as to how our department did. And overall, the news is overall very good. The faculty members are 100% compliant. Trainees and students also 100% compliant. APRNs are 100% compliant. And nurses and nursing-related disciplines, 100% compliance. That's a remarkable figure that everybody works so hard to really support each other through this process. It does include 14 religious exemptions and social work, nearly 100% compliant. There was one TAR position that we lost. And then it also includes 8 religious exemptions, but overall, social work, we did very well in terms of complying to the vaccine mandate. And the clinical and administrative staff also did very well, but it did include 5 resignations in the disciplines of OAS, therapist, and healthcare management. And we also had 17 religious exemptions. So where does that leave us with? Well, overall, as of September 27, 2021, we had 5 resignations for Department of Psychiatry related to this state vaccine mandate, and 39 religious exemptions were granted, and they are pending the October 12 court ruling that's expected. And if you think about the overall proportion, as I wrote to everybody this morning in our psychiatry or email, it could be seen as a small proportion. But from our perspective, 5 is still 5 too many. And that's something that we will continue to think about and continue to discuss and continue to have a dialogue over. To give you a perspective, for the overall medical center, there have been about 500 to 600 religious exemptions that are granted, and there were about 150 to 200 resignations across the medical center over this particular mandate. And, you know, after all, I just want to express my gratitude for everyone, especially for those who overcame hesitancy and received vaccination. Thank you very much. I know how difficult of the decision it was. I'm really sorry that you were in such a bind. And those who also filled out the religious exemption forms and worked that process through, I also thank you very much. It's a personal decision that's based on your faith. And we want to be there with you as you make these decisions. I want to particularly give my gratitude for those who really reached out and supported each other during this order. It's a sensitive discussion, and it's a very complex discussion. And by being able to reach out and being there for one another, you showed that you care for one another. So I just wanted to thank you. And I also want to remind everybody that this is not the end of this process. This dialogue about vaccine we just went through with the September 27th deadline. It will be followed by more dialogues about boosters, about how we manage COVID, and overall, this is all about also how we express our care for one another. After all, this dialogue about vaccine is about how we are concerned with one another, about caring for how someone that you care about can get sick, a family might get sick, and how our patient might get sick over this COVID-19. And overall, I just want to thank you for everybody for getting through this September 27th deadline, and so privileged and so grateful to be your chair. So thank you, and I want to pass it on to Rich for the Steinberg lecture.
Thank you, Ben. For those who I've not met, my name is Richard Ciccone, and I'm director of the Psychiatry and Law program. I want to spend a few minutes this morning remembering Charles Steinberg and to extend greetings to his family and friends who are joining us via Zoom. In 1988, on the occasion of Charles's 70th birthday, the department established the Charles E. Steinberg Lecture in Psychiatry and the Law. For almost 25 years, beginning in 1974, Charles gave grand rounds, lectured to medical students, conducted seminars for psychiatric residents on topics ranging from involuntary commitment of the mentally ill to psychiatric issues in family law. He was there in an important part of the establishment of the Forensic Psychiatry Fellowship Program in 1985. In each of these settings, Mr. Steinberg challenged the intellect and imagination of the students. He brought his rich experience from the courtroom to the classroom, along with his unfailing good humor. In 1996, he was promoted to clinical professor of psychiatry and law. On the national level, Charles Steinberg presented many lectures at the American Academy of Psychiatry and Law and was on the faculty of the Apple Forensic Psychiatry course. In 1986, he was presented with the Apple Amicus Award in recognition of his distinguished contributions to the interface of psychiatry and the law. With his death in May of 1999, the Department of Psychiatry lost an outstanding teacher and an esteemed colleague. I miss him to this day, and this is an opportunity to remember and to celebrate all his contributions to us as a department and to the broader area of the interface of psychiatry and the law. And now it is my pleasure to ask Dr. Robert Weissman, who is director of the Forensic Psychiatry Fellowship, to introduce our distinguished speaker.
Thank you, Richard, and thank everyone who is attending this wonderful presentation with Dr. Binder. I just want to take a minute to introduce Dr. Binder. Her accomplishments and her CV would take about 2 hours of presentation here, so we're going to boil it down in a few minutes, but there's so much to talk about. Dr. Binder served as president of the American Psychiatric Association from 2015 to 2016. During her tenure, she focused on decreasing the criminalization of persons with mental illness. She's a distinguished professor of psychiatry, founding director of Psychiatry Law Program, and associate dean for academic affairs at the University of California, San Francisco School of Medicine. Her research focuses on improving forensic evaluations and clinical and legal aspects of the relationship between violence and mental illness. Dr. Binder served as interim chair of the Department of Psychiatry at UCSF and the director of the Langley Porter Psychiatric Hospital and Clinics from 2008 to 2011. Since the 1980s, Dr. Binder has focused on the treatment and evaluation of persons who have experienced sexual or other types of trouble, harassment, and discrimination. In 2020 to 2021, she was a member of the APA's Task Force on Structural Racism. Dr. Binder received her medical degree from UCSF and completed her psych residency at Mount Zion Hospital in San Francisco. She's worked as a health policy fellow in the US Senate and studied health policy and management at the Harvard School of Public Health and Healthcare Leadership at the Stanford Graduate School of Business. She is the author and co-author of over 125 peer-reviewed publications. Dr. Binder has served as president of the American Academy of Psychiatry and Law and chair of both the APA's Committee on Judicial Action and the APA's Council on Psychiatry and Law. She is a recipient of the 2018 Isaac Ray Award from the American Psychiatric Association and the AAPL for outstanding contributions to forensic psychiatry and psychiatric aspects of jurisprudence. Let's all please welcome Dr. Binder and enjoy her very important and timely presentation entitled Sexual Harassment in the Age of Me Too. Welcome, Dr. Binder.
Thank you, Rob, and thank you, Richard, for inviting me to join you this morning or this afternoon. So this slide, closing the letter with very fondly yours, seems okay, but let's run it by legal to be sure it cannot be misinterpreted as sexual harassment. I mean, this is meant, of course, to be funny, but it has a lot of truth to it because institutions and workplaces are very confused about what sexual harassment is. People, for better or worse, are extremely sensitive to any kinds of issues of harassment and discrimination. And this is a very, very good thing. But the question is, what exactly is sexual harassment? And that's what I'm going to be talking about today. And I am focusing on sexual harassment and discrimination, but of course, what I'm talking about applies to all kinds of workplace harassment and discrimination. I'm also going to be referring to in most cases, the person who is harassed as being a woman who is harassed by a man, because that is the most common situation. But it's not the only situation, and men can be harassed, and there's certainly a same-sex harassment. So this is Anita Hill and Clarence Thomas. And this is in 1991. And I'm sure, as many people remember, this was during the confirmation hearing of Chief Justice Clarence Thomas, and Anita Hill said that he had sexually harassed her. It was a huge issue. People split. A lot of it was along gender lines in terms of women believing Anita and men believing Clarence Thomas. Psychiatrists got involved with it. The big supporter of Clarence Thomas was Senator Danforth, and he consulted some psychiatrists, and they said that Anita Hill had erotomania, and that's why she was making these allegations. And of course, many, many people supported Anita Hill. Of course, Clarence Thomas was ultimately confirmed. A similar thing, much more recent, were the confirmation hearings of Brett Kavanaugh. That did not involve sexual harassment, that the allegations by Christine Blasey Ford were sexual assault. But it's a similar sort of issue that I'm going to be talking about when it's a he said, she said situation. And the question is, who do you believe? My audience today is in New York, so I thought I would show this. What Mario Cuomo actually said is, I've never crossed the line with anyone, but I didn't realize the extent to which the line has been redrawn. And the point about the line being redrawn is actually a very good point in the area of sexual harassment, because things have changed. And what was acceptable in the workplace, or at least people didn't have, in my opinion, it was never acceptable, but there were not severe consequences if we think how people acted in the 60s and the 70s, the 80s, even the 90s. And the line has definitely been withdrawn. And nobody goes around right now calling people girls or think it's okay to touch someone on the rear end or, things like that. Things have definitely changed. So let's talk about the legal basis for sexual harassment. So the legal basis stems from Title VII of the Civil Rights Act of 1964. And Title VII prohibited sexual discrimination in employment. Sexual harassment is interpreted as a form of sexual discrimination as of 1976 in the federal district court, and as I'll be talking about in a few minutes, in 1986 in the US Supreme Court in the Meritor case. Then there's Title IX of the Civil Rights Act. So various acts have all kinds of titles, and Title VII refers to the workplace. Title IX refers to education, and that forbids sexual discrimination and harassment in schools receiving federal funding. During the Olympics, some of the women athletes spoke about how wonderful Title IX was, because once there was the Title IX amendment in 1972, there had to be equal funding for women's sports, and that's why we have so many wonderful women athletic teams. So when people talk about legal issues, when they're referring to the workplace, it's Title VII. And when they talk about what's going on in an education institute, it's Title IX. I'm sure University of Rochester has a Title IX office. At the University of California, San Francisco, we have a very, very busy Title IX office. Then there is the Equal Employment Opportunities Commission, referred to as the EEOC. And those are the guidelines of 1980. So the EEOC doesn't make the law, but the EEOC enforces federal law that prohibits employment discrimination. The definition of employment discrimination or sexual employment discrimination is unwelcome sexual advances, requests for sexual favors, and other verbal or sexual conduct constitutes sexual harassment when submission to such conduct is made explicitly or implicitly as a term or condition of an individual's employment. So an employer saying, I'm not going to hire you, I'm not going to promote you unless you have a sexual relationship with me. Or submission to or rejection of such conduct by an individual used as a basis for employment decisions affecting such an individual. I'll give you this promotion if you have a sexual relationship. Or, and the third thing is what people call hostile work environment. So such conduct has the purpose or effect of unreasonably interfering with an individual's work performance or creating an intimidating, hostile, or offensive working environment. So all of us are entitled to work in a harassment-free environment. So years ago, there would be posters up, there would be calendars up, people would make comments, and this is against the law right now. This is a hostile work environment. The way that people talk about these different kinds of harassment are quid pro quo. If you do this for me, I'll do this for you, and the hostile working environment. And of course, the most common type of complaint is the hostile working environment. Then there was the Civil Rights Act of 1991. And again, 1991 was a very important year in this field because it was the Civil Rights Act, and that was also the year that Anita Hill brought her allegations when she realized that Clarence Thomas had a good chance of being confirmed as Supreme Court Justice. So the Civil Rights Act extended compensatory and punitive damages to victims of employment discrimination based on sex, religion, and disability. Before 1991, you could only ask for compensatory and punitive damages for intentional racial or ethnic discrimination, and this was extended to sexual harassment. And compensatory damages are for monetary losses. You lost your employment, maybe you had different kinds of medical expenses, but the big issue is pain and suffering. And after this was passed, there were a huge number of lawsuits which continue to this day, saying that because of the acts of the employer, the person suffered emotional damages. And those claims can be huge. So this is a picture of Michelleinson, who is responsible for bringing these cases to the US Supreme Court for the first time. So Michelleinson worked for the bank vice president, Sidney Taylor, for 4 years. And then she started to take a lot of sick leave. Her version of events was that she just couldn't take it anymore because of what was happening in the workplace. The bank's version was, we fired her because she was taking excessive use of sick leave. After she was fired, she said she had been sexually harassed for 4 years. She alleged that she had a sexual relationship with Sidney Taylor, and she never reported it because she was afraid of him. So the district court looked at this and basically said, there's no, we're going to toss the case. The relationship was voluntary. He didn't rape her, she went along with it. And she didn't have economic suffering because for 4 years she continued to work there. And furthermore, the bank isn't liable for this because the bank didn't know that this was happening. I mean, just because there's a vice president who's having a sexual relationship with one of the employees, what does the bank have to do with this? They don't know what all their employees are doing. The Court of Appeals reversed it. It went up to the US Supreme Court in 1986. And as I said, this is the first sexual harassment case that ever reached the Supreme Court. And what the Supreme Court said was, even though the sexual relationship was voluntary, she consented to it, it still counts as harassment because the conduct was unwelcome. So the Supreme Court distinguished between voluntary and unwelcome. They also said that the employer's lack of knowledge did not insulate it from financial liability because a supervisor is considered the employer's agent. And they didn't know, that's too bad, that's their problem, but Merit or Savings Bank is still responsible. And they also said there doesn't have to be economic suffering. You can still have sexual harassment. And she didn't leave because she needed the job, and that should not be one of the criteria for sexual harassment. So this was the first case that reached the US Supreme Court, and it was a unanimous decision. In 1993, so 7 years later, the case of Harris v. Forklift Systems also went up to the Supreme Court. So Teresa Harris was a manager at Forklift Systems, and there were all kinds of sexist remarks and overtures. So the kinds of things that happened is she was asked to get coins from the pocket of some of the men, which of course they thought was hysterical and she was very offended by. They called her things and made comments like a dumbass woman. You know, when she asked for a raise, the supervisor said, sure, you know, let's go to the Holiday Inn and let's negotiate a raise there. The lower courts dismissed the case because it did not impact her psychologically and it did not interfere with her work. And then it went to the US Supreme Court. And what the US Supreme Court says, the law does not require psychological injury. And then the famous quote from this particular case comes from Sandra Day O'Connor, who at that time, of course, was a Reagan appointee, but she was the only woman on the Supreme Court. And what she said is, the law comes into play before the harassing conduct leads to a nervous breakdown. So this was a very significant decision. Then 5 years later, Ankel v. Sundowner also went to the US Supreme Court. So Joseph Ankel worked on an offshore oil platform. He was a man, and you know, everyone else on the platform was a man. He was called names. He was a gay man. He was threatened with rape, and he wound up quitting. And the district court said, well, this isn't sexual harassment because sexual harassment was meant to protect women. It's not meant to protect man, and it's not covered by Title VII. And the appellate court agreed with it. And it went up to the US Supreme Court, and they said, federal laws apply to same-sex harassment. So that also counts as sexual harassment. And then there have been a bunch of cases that have delineated the reasonable woman standard. So it used to be when there were jury instructions, they would say, in this kind of case and other kinds of case, members of the jury, you need to decide whether this would be offensive to a reasonable person. And when there were men on the jury, they'd say, it's not offensive to me, someone patting me on the back or someone patting me on the rear end. That happens in locker rooms all the time, and not a big deal. And the court changed it and said, it's not a reasonable person standard. It's what a reasonable woman would find offensive. And that's what the jury has to decide. So there were all these cases that came down from the US Supreme Court, and employers started to get very, very nervous about it. They said, wait a minute, you know, we have factories all over the world, all over the United States. We have thousands and thousands of supervisors and employees. We try and do the best we can, but we don't know what's going on in any one factory. You have a problem supervisor. Are we going to be spending all our time in court? Are we going to be spending all this money to settle these lawsuits? I mean, you've got to help us here. You know, we can't possibly run a business when those are the requirements. And so the US Supreme Court developed a two-part test that employers could use to try and say that they were not responsible for what happened. So they said the employer is responsible for setting guidelines and the employee is responsible for following them. So the employer has to show that they exercised reasonable care to prevent and correct promptly any sexual harassment behavior. So this was the beginning of all of the sexual harassment policies that were developed at every single company, every single university. And when you are hired, you're given a copy of the sexual harassment policy, you're given an employee handbook, and it says, sexual harassment is against the law. We want to have a sexual harassment-free environment. If you feel that you are sexually harassed, this is what you need to do. You need to file an informal complaint. You need to talk to your immediate supervisor. We have an office that you can talk to. We will investigate it. And we want to prevent this. And this became a cottage industry with everyone developing sexual harassment policies. But they said there also is an obligation of the employee. And the employee has to take advantage of the preventive or corrective opportunities by the employer. So cases are often tossed out because there was a sexual harassment policy and the employee is asked, were you aware of it? And they said, yes, I was. Well, did you file any complaints? Did you tell anyone? And they say, no, I didn't. And they say, well, then it's your responsibility because you should have filed the complaint and given the employer a chance to correct it. This is not that clear cut in a lot of cases. So a woman will bring a legal action and they'll say, were you given a copy of the sexual harassment policy? Yes, I was. Do you remember in it that it says you should report it to the supervisor? And she'll say, yes, but it was the supervisor who was harassing me. And they said, well, in the policy, it says that if you don't feel comfortable reporting it to the supervisor, then you report it to the supervisor's supervisor, or you report it to head of HR. And the woman will say, well, they all knew each other, they were good buddies, and I didn't feel comfortable doing any of that. And sometimes the case goes forward with that. Oh, there was a recent Supreme Court case, Bostick v. Clayton. It came down in 2020. And here it was a holding 6-3. And the majority opinion was written by Neil Gorsuch. So Gerald Bostick participated. It was actually 3 different cases that were put together. Gerald Bostick participated in a gay recreational softball league. And once the employer found out about it, he was fired. There was also the case of Donald Sarda, who was fired after he happened to mention to someone that he was gay. And then Amy Steffens was fired from a funeral home when during her interview, she presented as a man when she was hired. And then subsequently, she informed the employer that she planned to live and work as a woman. And what the ruling said, and this is a very significant ruling, said you cannot discriminate or fire an individual on the basis of their sexual orientation or on the basis of the gender identity. And so this was a huge win, both for the gay community and also for the transgender community. The important thing about this is it says it's a violation of Title VII of the Civil Rights Act. So again, that has to do with the workplace. It doesn't say anything about Title IX, which is education institutions, but it's certainly likely that it's going to be extended to Title IX. There may need to be another case about that. Okay, so I'm a forensic psychiatrist, and forensic mental health professionals are often consulted to help the court or the decision maker determine whether harassment actually occurred. And of course, when we're asked about this, we always say, we don't know. Whether or not the harassment occurred is decided by the fact finder, and that's the judge or the jury. In fact, most harassment occurs in private. There are no witnesses, and one person says it occurred and the other person says that it doesn't. I mean, there are occasionally cases where there are multiple plaintiffs who come forward with the complaint about the same offender. And then it's not a question of credibility. It was a problem employee, a perpetrator, a predator who just had many, many, many victims. But that's not the typical situation. The much more typical situation is where he says, I'd never do that. And she said, absolutely, you did. So the credibility of the victim becomes an issue in the lawsuit. And we can be helpful to the courts in issues of credibility. So one of the areas of expertise that we can give to the court, again, just saying that whether or not it occurred that's up to the fact finder, but we can give an opinion about whether the behavior of the victim is consistent with other victims. So one of the questions that sometimes comes up in these cases is, why didn't she report it? Or why, if it was so terrible, why didn't she report it for 6 months? Why did she ignore the harassment and continue to work? And it can be very helpful to say to the court, this is not unusual. There are many reasons why a person would not report harassment. She hopes it'll go away. She wants to ignore it. She's embarrassed about it. She's worried about her job. And that fact alone should not be just because that happens, it doesn't mean that the sexual harassment didn't happen, that can be very typical behavior of a victim. The other question that comes up is this woman paranoid? Is she distorting what happened? I mean, someone touched her shoulder by accident, and all of a sudden she's saying, oh, he's groping my breasts. And, is this woman who just overreacts to everything that's going on? And you have to look at the facts of the case. I was involved in a case where the comments by the supervisor was, they were talking about real estate from his perspective. And he made the comment, you should let your house work for you. And she interpreted the comment that meant that he was telling her to be a prostitute. There was a case of a woman who alleged harassment, and she had made other allegations of harassment in other workplaces. And it was unclear what happened in this particular workplace, but she had a psychiatric history. And when she was hospitalized, she made allegations against one of the attorneys who was representing her in a civil commitment hearings. And the notes were available of that. The nursing staff noted that there was a hearing on the ward about whether she should be released in the hospital. And the typical behavior of the public defender would be that he would go and he would meet with the patient and say, I'm sorry, the judge, the commissioner said that you need to stay in the hospital, or I have good news for you, you can leave the hospital. And this woman said that he came into the room and he told her about that, and then he hugged her and he fondled her breast. And the nursing staff said, we know this public defender. He's worked with us. He defends all of these cases. He's been on the unit for 5 years. There has never been an allegation against him. I mean, anything is possible, but it's extremely unlikely. And so this came into the courtroom, that this is someone who has made allegations which have seemed to be unsubstantiated. Another issue is the significance of the time course of revelations about harassment. So when someone brings a claim of harassment, they often have to go through a variety of reports. There's an internal report, there's a report to the Equal Opportunity Office, there's an investigator. And in all these reports, the typical response of the investigator is, can you tell me everything that happened? Was there anything else that happened? And in some cases, a woman keeps adding details. So at first it was he touched me, and then it was he kissed me, and then he had a sexual relationship with me. And it may be that she is embarrassed and she doesn't want to talk about it. It also may be that she just has blocked out all the memories of it. And as she's talking to people over, let's say, the course of 6 months or so, other details come up. So it's good to explain, and of course, another possibility is she's just adding details, as she's reporting it. And so you have to look at all the facts of the case. And then a lot of these cases start when someone gets a poor evaluation or when they're terminated. And this also can be very helpful to the court. Are there alternative explanations for the poor evaluation? Has she received poor evaluations before the alleged perpetrator even worked at the company? Did she get poor evaluations at other places of work? Are there other reasons for termination? Is she accused of fraud? And so, you know, the person who's bringing the allegations will say, no, I was terminated either because I refused to cooperate with the request for sexual favors or because I reported it and it was retaliation. And then, of course, we're asked, what is the current psychological condition and causation? What are the effects of retaliation as well as harassment? And there is a range of reactions. And in doing this sort of work, it's really important to understand that women can react in all kinds of ways. And the effects of retaliation are very serious also, because I was involved in a case where it was a nurse in a jail facility and she was divorced. She had a son at home and one of the correctional officers asked her out for a date. She said, I'm sorry, I'm not interested. He kept asking her, he cornered her in the medication room and she felt very threatened by it. And she reported it, which is exactly what she was supposed to do. And he was suspended while they were investigating the case. And then several of the other correctional officers got very upset with her, said, you know, this guy has a lot of problems. His kid is having problems. You got him suspended. Why did you do this? Now he doesn't have any money. He has all kinds of financial difficulties. And she said, because I wanted to stop this kind of behavior. And she reported that the other officers were so angry at her, and she started to feel concerned about getting hurt. She told me that when she would go to the various jail cells, sometimes you would hand the medications to the inmate, but sometimes you had to go inside. You had to give them an injection, or you had to do mouth checks or things like that. And she was afraid that she was going to be attacked. And she was accompanied by correctional officers. And she said they were so angry at her. What she was concerned about is that they would delay a few seconds before they reacted. And they'd never get in trouble with it because no one would even know about it. But in the meantime, she would get beaten up, and she was the sole supporter of her son. She just felt she couldn't work there anymore. And so the issue that caused her terrible psychological distress was really the retaliation. So it's almost 12:45 right now. And I think what I'm going to do is stop and open it up for questions, because I'm sure there'll be a lot of very interesting questions from the audience.
So audience members know that they can ask Dr. Binder questions. You put them in the Q&A spot on your webinar. That's usually for most of us on the window at the bottom right. You'll see the little icon for Q&A. So please type in some questions or thoughts for Dr. Binder while we have her. While we're waiting for some questions, Dr. Binder, we collected a few questions beforehand, and let's start with the first one. What, and this is a bit outside of what you're talking about, but I believe relates, what is our role as psychiatrists in protecting ourselves and fellow staff from sexual harassment from the patients that we serve?
Yeah, so the first thing is always to report it. You know, that, well, first of all, you know, it's good to have good boundaries with patients, to communicate the fact that we have boundaries with the patients. There's certainly appropriate behavior and there's not appropriate behavior. In a therapeutic situation, everything can be interpreted, everything can be dealt with. But If someone is in a situation and they feel that they're being sexually harassed, you need to tell someone about it. It's not the time to keep it to yourself. And then you get help about someone who's not as emotionally involved with it or doesn't feel victimized by it. You have a colleague step in and help you with it, consult with you. If you're a trainee, absolutely you want to tell it to a supervisor. That behavior is just not acceptable.
Thank you, Dr. Binder. And we're starting to get into some questions. Just a follow-up to that question is, so we asked about our as psychiatrists, as doctors, our sort of reporting role and limit setting. What about the institution's role in protecting us as providers from the sexually harassing patient?
The institution definitely has a responsibility. And that's why we have to, all of us, again, it's embarrassing sometimes, you don't want to say anything, but you absolutely have to tell someone. And the institution has a responsibility to protect us. It's the same thing with violence. I mean, we get in this with, with residents, they're feeling threatened or, something. And then, they feel they should be able to handle it themselves. And, they don't want to make a big deal out of it. And the institution absolutely has a responsibility to protect everyone who works there. But in order for the institution to do it, you have to report it. And if any individual feels that they're not getting adequate help, then they need to go to someone else. We all have the right to work in harassment-free, violent-free environments.
Great. Now to some of the questions that have been posed. The first question is, how has the court looked at juveniles and the boundaries of harassment?
I'm not sure what that means.
Yeah, it's a bit unclear, but maybe what is their maturation or level of responsibility or accountability? I'm reading into this to think about if they are harassing. And maybe the person who submitted that question can clarify. But one sense is that do juveniles understand or appreciate that boundary?
It depends.
Yeah.
I mean, anyone can say anything, anyone can do anything, people can touch you. The first step is always setting limits. The first step is trying to deal with something informally. Many people, have been asked out on dates by patients, or a patient has, can I hug you? Or, comes too close, and you can say, that's not really acceptable here. I'm your psychiatrist, I'm your therapist. And, same thing with juveniles, with acting out behavior. There can be all kinds of acting out behavior. And the first step is to set limits and to try and keep it from happening. And then if that doesn't work, to get some consultation and to get some better ideas about how to do that.
Excellent. Do you have recommendations for those who are falsely accused of discrimination, the investigation and the possibility that false rumors are spread and how that can be isolating to the person who's being accused?
There can be false allegations. And when you have, one preventive strategy is if you feel in an uncomfortable situation with someone who might be misinterpreting something that you're doing or is making allegations, the first thing you do is you tell someone about it. Say, I don't know, what's going on, but they're making all these allegations. That is a huge help. You document the encounter. You tell a supervisor about it. Just because someone makes an allegation doesn't mean that it's true. And
with reference to the Anita Hill, Clarence Thomas hearing, what would have been a systemic approach to assessing the she said, he said dilemma?
Well, one way of doing these things, and this comes up in much less much lower profile cases, is this believable in terms of other behaviors of the alleged perpetrator? I mean, people who do these sorts of things, they're usually, it's unusual for it to happen once. It can just happen once. But the much more common scenario is that other people notice things. In these harassment lawsuits, again, these are the civil cases, what typically happens is there are depositions or reports taken of everybody in the workplace. Did they notice anything? And if someone says, yeah, they never did it to me, but I noticed it, and I thought they were inappropriate. I was at a meeting where they said something inappropriate, or they say, absolutely not. I mean, anything is possible, but I have never noticed anything about the behavior of this person. So in these kinds of cases, is this something that's just out of the range of possibility, or has this occurred before with some other people? And that's a way of trying to investigate. And sometimes you just don't know.
Right, and as you emphasized, I think in the best practice of doing these evaluations, you suggest obtaining collateral, getting as much history as possible, whether to find some level of pattern or prior behavior.
And if there's no collateral, then you just don't know. I mean, I've been involved in these he said, she said cases where the perpetrator absolutely denies that anything happened. And then I've spoken to the person who's making the claims, and they said, absolutely, it happened. I mean, I don't imagine these things. And I'll say, have you felt other people have harassed you in the past? Never. Never anything has happened. You evaluate, do they have any psychosis? Maybe they're imagining things. Maybe they distort things. Do they have any cognitive difficulties? Do they have an alternative motive or things like that? And, you go back to the attorney, you say, I have no idea what happened, but she believes it happens. And he absolutely denies that anything inappropriate happened. That's the best I can do.
Excellent. I want to again invite the audience to submit questions. In the meantime, I have another question. This really looks at, I think, statute of limitations. It says, as this has come to more awareness, it allows one to rethink previous interactions that have occurred and may have, quote, crossed the line, unquote. How do we process or manage this without becoming the next person to call the media and accuse someone from 5 to 20 years ago when it's appropriate to raise the issue after the fact?
Yeah, I think this is a national conversation. The argument, I mean, as I stated at the beginning, rules about this and attitudes and culture have changed. I mean, things that nobody even worried about years ago. It's just how it happened, what went on in the workplace, and now it's being brought up, as being inappropriate. And it's absolutely inappropriate looking at it in 2021. But whether it was inappropriate in 1970 or 1980 is another issue. So how far back do you go? I mean, it's a different situation if it's a rape, a sexual assault. But when you're talking about trying to date someone in the workplace, making comments about people, it's just things have changed.
Absolutely. And I'm just thinking myself as we're doing this over the internet, the Zoom presentation, the questions, what about so much of our work now, and I was just asking this question, so much of our work now is over these webinar-based programmings. Have you seen any eruption of sexual harassment claims because someone chatted something to someone else during a work time Zoom or WebEx, and or maybe other more severe sexual harassment accusations?
Well, maybe I should have said this in terms of, what counts as sexual harassment. It's not one comment. Yeah. It has to be much more severe. I'm an associate dean of faculty affairs at UCSF, and we get lots of complaints from people, and they say, I think it was inappropriate. And of course, the right response is for me to say to the person, is it okay with you if I talk to the person, because there's, if you want me to keep this confidential, I'll keep it confidential. But how about if I talk to the person who you feel made the comment, or you could talk to the person, and what if we bring it to their awareness and they apologize to you? How will that feel? And very often that just is fine. And you talk to the alleged perpetrator, you know, and he says, I didn't realize it would come across that way. Or he'll say, I can say whatever I want, you know, no one's going to tell. If she finds it offensive, that's her problem. And I'll say, it's not her problem, you know, and
Right.
You have a choice here. You know, you are in the workplace. This is not acceptable. There is going to be a complaint. It's possible that we're living in different times right now. And how do you feel about meeting with the person? I can be there, someone else can be there, and just apologizing, and just don't do it anymore. We're living in very different times. So, you know, that's always the first step.
For sure. This next thought is looking for some advice, and you have talked about this already, but it said in academic settings, mentees have a lot more at stake when dealing with sexual harassment by mentors or any authority figure, since they need to receive or finish their degree or education rather than leaving. Are there good recommendations for mentees in academic settings to handle such sexual harassment during that time?
I think it's a big problem. You know, it's not just sexual harassment, it's bringing allegations against a mentor, against a PI, you know, in a laboratory, because it can affect your whole career. And when people come to me, this is in my role in the institution, and tell me about these things, I always go over with them just to make sure that it's fine to bring that, just to give them choices.
Mhm.
And the choices are, you can bring a complaint, that's just fine. You can try and bring a complaint anonymously, which you can get other people to file it, and it's all anonymous. And then when you meet with the, you know, problem PI, you can say there have been several people, and they say, well, who is it? You know, maybe it's someone who's, you know, isn't doing their work. And you say, well, it's been several people. So you can do it anonymously. But it is a problem. Retaliation is against the law, and you're not allowed to retaliate. I wrote an article, it was published in Academic Medicine, about covert retaliation, because that's what we come up against, that people, faculty members, junior faculty members, residents, you know, postdocs will say, I know retaliation is against the law, but I'm not worried about overt retaliation. I'm worried about covert retaliation, that I'm going to be up for an award, for a grant. You know, the senior person is going to be on the committee, and it's so competitive, and, or, you know, position at another university or an award. And I mean, I've been on those committees. I'm sure a lot of people have, and you have, you know, one fantastic person compared to another fantastic person compared to another fantastic person, and you have to kind of choose. And if one person makes a comment, oh, you know, I don't know all the details, but I think maybe they had some trouble when they were at UCSF, that person is eliminated. It makes it easier for the decision committee to say, okay, now we only have two fantastic people to choose from. And that's what people are afraid of, or getting a recommendation. And I don't know how to protect against that, but you have to people have to be aware of that.
And just to reference what you said, the article that you wrote, that was in Academic Medicine.
Yes, and it's called Covert Retaliation. I can't remember the exact title.
Overt retaliation.
Covert. So it's
Covert.
not overt, but it's kind of like this informal thing where someone calls you up for a reference and says, just give me the lowdown, you know, on this person. It's a high, you know, we're looking for someone. What are their strengths? What are their problems? And I'll never tell anyone that I got it from you. Yeah, I'm the first author on the paper.
Your first author. Thank you, Dr. Binder. So I'm aware of the time. We're at the 1 o'clock hour. I want to be mindful of your time, Dr. Binder, and all of the audience members. I want to thank everyone for joining. If there are additional questions, please share them with the Skills Lab. And Dr. Binder has been so kind to agree to review those questions and respond at her earliest convenience. Again, I want to thank Dr. Renee Binder from UCSF for today's wonderful Steinberg presentation. And I hope all of you have a safe and enjoyable rest of your week. Thanks again.